The biggest mistake founders and entrepreneurs often make when it comes to their brands and their trademarks is that they assume that either by buying the domain name or the URL for the brand that they want, or by registering their business name in the state, say maybe they formed an LLC and they think that by using the name to form the LLC, that gives them a trademark and trademark protection. But unfortunately, it does not. What we need to talk about today is the difference between buying a URL or business registration and having trademark rights and ultimately trademark registration. I also want to talk about the difference between domain names and trademarks. So let's first talk about the business registration side of it. So when you file something with your state to claim a name, and the state grants you that name because maybe nobody else in your state is using that exact same name in your state, that is not giving you trademark protection. What creates a trademark is not claiming the name on a state database. And some people will even file for a trademark registration in their state. That takes it a little bit further. That does give you some protection in your state. But what really gives you trademark protection is using your trademark in commerce. And what that means is that you are actually offering goods or services for sale with that mark affixed to those goods or services as the brand. So for products, it's going to have to do with, is the mark on the product itself? Is it on a hang tag? Is it on the packaging? And for services, often it'll be a brand that is on your website or maybe on your services page or your shopping cart if somebody's buying something from you on the internet or a service from you. And it's the use of the mark in making those offers that begins to create trademark rights. It isn't enough to just register the name with the state, particularly if it's just through forming an LLC or forming a corporation. You have to take it a step further and actually do what is necessary to legally claim that name as a trademark. There are two types of trademarks in the US. There are what are called common law trademarks, and then there are federally registered trademarks. Those are really the two we're concerned with. Now, there are state registered trademarks as well, but the ones I want to focus on that are the most common, because most entrepreneurs and founders do not file for a state trademark registration. So when you start using your mark, you get out there, you launch your website, you start offering goods or services for sale in your community, you are using the mark. And so that's when your trademark rights begin to accrue. But what you only have in that instance is what's called a common law trademark. And common law trademarks do give you some protection, but they are very limited in geographic scope. They're really only going to protect you in the market that you're doing business in. And so that nobody can come into that geographic area and use a name that is confusingly similar to yours, but it's very limited, right? You're not going to be able to protect yourself beyond the scope of that geographic space. And so generally it's going to be maybe your state, maybe not even the full state, especially if you're in a big state like California. Whereas federal registration is going to give you protection across the entire United States so that nobody else can use your name. And the reason this matters is because even if you don't have an intention to, have this huge business across the entire United States, if you don't have your name protected and somebody else decides to use a name that's similar to yours and they want to have a big national business, you could end up in a situation where they push you out or corner you into your small geographic area and you can't use your mark in any other way. And you may end up in an infringement lawsuit with them. And so every entrepreneur needs to protect their name on a federal level through federal trademark registration if they qualify for it. I'll tell you really quickly, trademark registration, the protection that it gives you is that it gives you the ability to enforce your rights. You can go to court and stop people from infringing on your mark or using a mark that's confusingly similar to yours in your industry, basically. And you can collect money damages if somebody's profiting off of your trademark or one that's confusingly similar. So having federal registration is a very powerful tool. And also the fact of federal registration will deter other people from using your name or something confusingly similar in most instances. So it is really important. If you're spending the time and money and energy to develop a valuable brand, you must take the steps to protect that brand. You don't want to have it watered down or end up in an expensive dispute with somebody later because you didn't take the steps to protect it. And I've had clients that have been in business for 5 or 6 years and are very successful, but never registered their trademark federally and ended up having somebody copy them They ran and got federal registration first and then challenged my client for the name. And my client would end up in expensive litigation and would have to make the decision about whether they wanted to fight it legally or just rebrand. I don't want you to ever end up in that situation. So the most important thing you can do, and the biggest mistake founders and trademarks make when they launch, is not protecting their trademarks by, first of all, talking to a trademark lawyer that can help you do a proper search to determine if the name and brand is available to you. Doing a search on the USPTO database is a good start, but it's not enough. It's not sufficient. And a good trademark lawyer will have access to a paid database to help you determine the likelihood of you being able to own that mark exclusively. You must do that research up front. And once you know that you can own it exclusively, then filing for trademark registration in the US will give you that protection so that you know you can own the brand exclusively and get on with the business of building your brand without the risk that you could lose those rights sometime in the future because you didn't protect them properly. Now, I mentioned earlier, the other issue is people will often search for the URL or the domain name, and then it is available, or some form of it is available. Maybe the .com is not available, but a hyphenated version of it, or a .co version, or .net version, or whatever is available. They think they can use it, and they think that that gives them some type of trademark rights. The reality in the US is that having the URL doesn't give you any legal rights whatsoever in a trademark. And in fact, if you buy a URL in a name that's actually federally registered to somebody else, and you guys are in the same industry, so you're actually competing with them, and the mark is confusingly similar to this existing registered mark owner's brand, that mark owner can actually come after you for cybersquatting and take the URL away from you. The URL actually gives you zero protection. So it's great if it's available. If the .com version is not available, I would be very hesitant to use that brand until you understand how it's being used and make sure it's not in your industry. If it's not, then maybe you can use a different version of the URL, but it's a very big red flag if the .com version of the brand you want is taken. So understand that the domain name, the URL, does not give you any legal rights. The only thing that will give you the rights you need to own the name exclusively and enforce your rights against any other person or business in your industry is a federally registered trademark. That's my recommendation, and I don't want to see you leave your business exposed. If you are curious about this, if maybe you haven't done the work to protect your brand or even know if the brand is one that you can own, call me. Let's set up a call. Let's talk. I can walk you through it. I'm very good at being able to establish whether a brand is available or not. And I have a high success rate in predicting what's going to happen when it comes to trademark applications with the USPTO, which is the United States Patent and Trademark Office. And so let's have a call, and I will help you make sure that the brand you're using is one that you can own exclusively, one that we can get federal registration in for you, and one that you can protect and monetize, which is really the goal at the end of the day. Your brand is ultimately one of the most valuable assets you will have in your business. So let's make sure that you protect it. Reach out to me, and I'll make sure that your business is protected and not exposed.